Welcome to the Cooper Show. This is the 4th episode. And today we are discussing the case which has rocked social media quite hard. It has also rocked the corporate world. But at the same time, it has really brought a lot of uncertainties for a lot of inventors, a lot of people who are creatives, because there is a need to bridge the gap between the law as well as creativity, as well as protection of ideas to ensure that there is a proper compensation for people who create and invent. Ladies and gentlemen, we are talking about the Nkosana Makate case together with Vodacom. This is a case that has been in court, or this is a case for which a dispute has been in progress from 2001. Believe you me, this case is only settling in 2025. I bet there are some of you who may be watching and tuning onto this show who were not born in 2001 when this case began. Mr. T.
Hi, Mr. Cooper. How's it going?
It's going well, man. It sounds like today we are really getting into the nub of what has been a stress for Mr. Makate for, 20? How many years has it been?
No, not just a stress for him, a stress for the judges as well that have had to preside over this matter for so long.
You're quite correct, because this is a case that has been from one court to the other.
Yes.
And eventually there is a solution to it, but it comes from no court. Right?
Comes from the parties.
No court. Right? I think which also speaks about the importance of the power that the parties have to be aware that they have towards resolving their own disputes.
Yes. I think this goes back to our earlier episode, the first episode, the importance of mediation, you know?
Right.
I think it could have solved so many issues.
Right.
But I suppose because there was so much evidence in this matter,
right,
at the time they weren't sure which expert to go with. But I think as the case went along, they sort of got a clear picture that, okay, I think both parties have a case here. It's just a matter of the quantum in terms of the amount, the exact amount. Yeah.
Yeah, because I think they picked up quite early, and I think we'll dwell into the factual context, of course, shortly. But I think both parties picked up quite early that there was a case.
Yes.
On merits.
Yes.
That Mr. Makate was making.
Well, yeah.
And Vodacom itself was not disputing the origins of the idea itself.
Yes.
Like you are saying, the issue was determination of compensation.
The exact amount, yes.
And also profitability of the idea. Like, I think we shouldn't be too technical. Let's get into the factual context. Maybe you want to just explain what is the Please Call Me case and where does it come from and how does it come about?
Okay. So what I'll do is to explain the facts, I'm going to read directly from the judgment of former acting Deputy Chief Justice Madlanga.
Yes, he's Justice Madlanga is now retired.
Yes.
He just recently retired with this case. This was his last judgment.
What a monumental moment.
What a monumental moment. And I don't know, but I feel like usually the tradition in the Constitutional Court is that when your time has come to retire, you are given a high profile matter to deliver a judgment on.
Yes.
And what usually happens is I feel you would want to go out with a bang, whether you deliver a landmark judgment.
Yes.
Or if you can't, then you ensure that from your judgment we read of something. You chastise the ones who have failed, for the judgment to end up in the Constitutional Court or not. And indeed, did he not take a moment to chastise the Supreme Court of Appeal majority?
That was a shamboking.
Well, shout out to Justice Madlanga. He's now leading the Madlanga Commission.
Yes.
And I think, you wanted to dwell into what he said in this judgment.
Yeah, so how he describes the whole Vodacom matter, I quote paragraph 5 of his judgment.
Yes.
Mr. Makate, then a trainee accountant at Vodacom, came up with what Vodacom itself describes as a brilliant idea. The idea was that a cell phone user with no airtime could buzz a user with airtime, and the latter could then call the former. The attraction to the idea was being able to buzz or give a user a missed call whilst the buzzer had no airtime. The idea was a trigger for Vodacom to develop PCM. Close quote. PCM is the please call me.
Yes.
So when Mr. Makate was a trainee at Vodacom, came up with this idea that you could send a message without you having airtime to another user who may or may not have airtime, indicating to them that you'd like for them to call you back.
Right.
The idea was then developed by Vodacom. It became commercially successful. Makate had apparently entered into an agreement with a manager in the organization.
Khresla, yes.
Khresla, yes, if I'm not mistaken.
The famous Khresla, yes.
Got into a lot of trouble, I'm sure, at Vodacom. But so the court then pronounced that, yes, there was a valid agreement that because of this idea and it became commercially viable,
Yes.
Mr. Makate was then entitled to a revenue share.
Right.
Based on whatever the calculation was, based on how many calls people made as a result of receiving a please call.
And the advertisements attached to it, because if you recall how it worked,
Yes.
was that Vodacom could then incentivize the
Yes.
idea by saying, you funeral cover on this free message that would be sent from one user to the end user, we could add your ad, to say, please call CPA, and then below it would say, this is a funeral cover you can take for 399 rands per month, and then they would pay Vodacom for that. So it was low cost generating, revenue generating idea,
Yes.
which for Vodacom, which, as you are saying, would have over the years generated a lot of money. But before we get into the commercial aspect of it, I just want to deal with the social aspect of it, because you see, and this is for a lot of people at home who actually used this idea without knowing how far-reaching and the brilliance that was associated with it. Because in 2001, we barely had fiber.
Yes.
So text messages were quite expensive compared to now.
Yes.
I mean, if you were born now in 2011 or 2008, you'd think we're talking gibberish. It was hard.
Yeah.
I mean, it's better because during our parents' times, they were sending telegrams, actual letters, post.
Yes.
You understand? Now, during people who were born on the 80s and all of that, they were sending a please call.
Yes.
And it was also very effective and important for romantic relationships.
You remember we used to send, please call, I love you.
Oh, please call, I'm outside. Please call, I'm outside. Thanks to Makate. Thanks to Nkosana. There are
Very
relationships which were
revolutionary idea.
built on please call, I'm outside. Kids were born.
Dare I say we were born as a result of that?
Kids were born. Please call, I'm outside. So this is the idea.
Yeah.
I bring the social aspect to this because we often fail to appreciate brilliance because it becomes too familiar.
Yes.
The ideas become so familiar, we undermine their significance and role, especially from a commercial point of view.
Yes.
So this is what we're talking about. There are kids who are born today because Makate made it possible for the dead to say, please call, I'm outside, but without deviating from what you were now getting into in terms of the factual context. Yes.
Before we move on, was the backstory not that Makate at some point wanted to contact his girlfriend? But at some point, I think the girlfriend didn't have airtime, so she didn't know how to say to him, babe, I want you to call me at this time.
Well, I'm not sure.
I think the girlfriend may have a claim.
That would be interesting. I'm not so sure if, I don't know the social story to the genius, right?
Yeah.
But I think it would be interesting to hear from him how this came about. Because if that's the case, really, the girlfriend must be thanked, because it would not have been possible
If
to originate the idea without her.
Yeah.
But be that as it may, I think it's a genius idea, and I think it really has brought a lot of, or dominated the social media, dominated our courts, dominated the commercial law, because I think a lot of commercial companies, a lot of in particular telecom companies, have looked at this and they've said, we don't want to be in the same position tomorrow.
Yes.
But we still want to attract creatives. We still want to attract people and encourage people to, bring germane ideas, foreign ideas, unknown ideas, and innovation into our companies. So how do we tighten the belt?
Yeah.
So maybe just from that aspect, what, as a company, what do you do to ensure that you still have creativity, but at the same time, you don't compromise
in terms of the IP,
in terms of the intellectual property?
Yeah, I see a lot of companies are probably going to go for an intellectual property clause in their employment contracts. What that clause basically stipulates is that anything that you create during your term of employment that is creative or inventive or has IP attached to it would become the property of the company, right?
Right.
Depending on how they compensate for that, that would be an internal policy sort of thing. But now my conversation is that, are they going to do it for everyone? Because I mean, surely a cleaner is not brought into the company to bring up ideas or innovation.
Right.
Will that also then apply to them? Where do the courts draw a distinction?
Yeah.
Because I think that was one of the main things in this case, is that Makate was there as a trainee accountant,
right,
not necessarily for innovation and development.
Right.
And that's what sort of solidified his case to say he should be entitled to some kind of revenue split as agreed between
Mr.
Geisler, the legendary Geisler.
Yeah, so Geisler, how he became famous and so popular, at least in my mind, is he got in trouble for failing to manage the entire thing. And at some point, in the beginning, I understand when he presented the idea, he did not present it as an innovation that comes from an employee. He presented it as an idea that comes from him and the employee at some point. That's where the entire thing, begins.
Yeah.
And obviously later it becomes known that this is an idea that originates from Mr. Nkosana Makate, So, yeah, I guess the English phrase appropriate for or fitting for that is the chickens will always come home to roast.
Yes.
And when that happens, it's not so nice,
Not nice.
So yes, I did hijack you.
Yes.
And I appreciate what you are saying about corporates being more vigilant, being more careful, to have clauses in the contracts, especially employment contracts, particularly for innovators, that would specifically state that the ideas that are generated in the course of employment, within the scope of employment, for the purposes of advancing that particular industry which the company is serving in, would belong to the company.
Yes.
Period.
But does that extend to your particular role, or in general, the running of the business? Because, I mean, if you come up with an inventive step as an accountant in the accounting, let's say you come up with something that relates to drafting financial statements, for instance.
Yes.
Will it be limited to that? Or if you come up, for instance, with the please call me, does that also still apply?
Yeah.
And what is the compensation? Because an innovator, they're there for innovation.
Right.
Their salary is compensating them for that. But if you're there for something else and you come up with something that's brilliant, how then do we distinguish?
But isn't that the precedent that the Makate case sets, right? That it's not limited to your role. that it extends, your entitlement as an innovator to compensation extends beyond your role or your identified role in terms of your contract.
Yes.
That it goes to whether or not there is a commercial benefit derived from your idea by the company. And if there is, then there must be a proportional benefit somehow that accrues to you for whatever idea you have brought. Would it not be the case that that's what the entire Makate saga has now said?
Yes.
Because that's my understanding.
Okay.
Yeah, that's my understanding. Because as you said, Please Call Me was not his line of work. He was a trainee accountant.
Yeah.
Right? And and look where it landed, man. I think we should talk about his tenacity, though.
Yeah.
His patience.
Very resilient.
His resilience.
2 decades.
Oh, my thinking is, because you never know when you'll die.
Yeah.
He could have died in 2014. Like, this is just for example.
Yeah.
Right?
God forbid.
He could have died in 2014 and the saga would still not have ended. And this would not be from lack of offers having been made to him. But I guess if you know and believe in the value of your work,
yes,
then you're not going to give up for something that's less.
Yes, that's very true. Let's get into the judgment.
Right, yes, the fictional context.
SCA judgment. I don't know if you want to maybe take why the Constitutional Court sent back the judgment of the SCA back to it to reconsider in front of a new panel of judges. Yeah, no, because before we get to the why, maybe let's just explain for those of our viewers who've not really read the judgment, right? That for now, we've said there was an application made by Vodacom, which was an appeal against the judgment of the Supreme Court of Appeal to the Constitutional Court, in terms of which they were challenging, as you slightly alluded to, the outcome on the basis that, one, there was an issue of cross appeal that was raised. And Vodacom was saying that the Supreme Court of Appeal entertained an issue that was not before them on appeal. And that deprived Vodacom of a right to reply to that, because if a court on its own volition, Meromotu, brings an issue about which the matter has nothing to do with at a stage of judgment, then you have not had a right or an opportunity to make submissions. And you would know that each party in any matter is entitled to a right of reply. It's called audi alteram partem. Right. So that being said, there was that issue of cross appeal which was raised to the Constitutional Court to consider. Secondly, there was an issue which was raised by Vodacom to say the judgment is appealable because it did not give a proper consideration of the matter or the issues which were brought before it. And that's where, in my view, I found that the Constitutional Court took time to chastise the majority judgment in the SCA on those bases. Now, those being the issues, that's what the Constitutional Court had to speak on or pronounce on. And it was an appeal. It was opposed by Mr. Makate, and there was then a judgment. And I think the outcome of that judgment was simply the Constitutional Court took a unanimous decision, right, to say that Vodacom has made out a case on appeal. That one, the Supreme Court of Appeal majority judgment failed to give a proper consideration of the issues before it. And they then tallied that with Section 34 of the Constitution to say, in doing so, that deprived Vodacom of a right to a fair hearing. Secondly, they then said, on the basis of the issue of cross appeal, Vodacom is correct. A court cannot on its own, especially a court of appeal, bring about issues that are not before it
and make determinations. There's a part, I think, just on proper consideration, where Justice Madlanga says, with all due respect, the majority judgment is confused and confusing. On one hand, they say that is it 7.5 or 5%?
Yes.
Right? Entitlement on interest was agreed by the parties. On the other hand, they say it was a ruling of the Constitutional Court that entitled the parties to that 5%.
Yeah.
At some point, they go back again and say, well,
I think it was the revenue was the 5%.
On the revenue.
Yes,
right.
On the revenue.
So he says that level of confusion, at the very least, is unacceptable.
At that level. And there was also confusion regarding, the SCA basically ordered that Makate is either entitled to between 5% to 7.5%.
Yes.
And the Court was saying, but that's a very vague judgment because obviously if I'm Vodacom, I'm going to go for the 5%.
But if I'm Makate, I want the 7.5. So where do you draw the line?
You see, then we still have a dispute. Also, on the judgment, the Court does point out that the SCA failed to consider the CEO's arguments in terms of the calculations of the quantum.
Right.
On paragraph 75, basically, the CEO points out that Makate is arguing that 80% of Vodacom's total mobile voice revenue can be attributed to the Please Call Me.
Yeah.
Now, personally speaking, I mean, Vodacom is a big entity. I just don't see how the one innovation can, account for most of its revenue, and I think that might have been an oversight as well for the Supreme Court not to consider that affidavit by the CEO.
Right, right. I agree. And look, they because determining the figures was such an issue, the court ordered previously that an expert be appointed to make a determination. And if you really contend with the evidence in this case, you'll realize that a lot of considerations were made in trying to determine an appropriate amount that would be a fair amount, fair and just amount for both parties to pay and receive. And I think the person who was appointed to make that determination is a former employee of Vodacom who understood this entire industry quite well. And he used 4 methods or formulas of determination. And of them, he took the last 2, which were like the best 2, and averaged whatever outcome of the 2. And it took him to 47.5 or so million that he then said, I'm determining this to be a fair compensation. But Mr. Makate said no.
What are your thoughts on that? What constitutes fair? Because honestly, an idea is an idea.
Yeah.
You still need to put the risk of marketing. You need to, there's so many things that go into it. What would you consider as being fair for an idea?
Yeah.
Remember now, it's an idea. You haven't developed a business plan. We still need to do the feasibility studies. We need to do everything. What is fair?
Yeah. So in the context of this case, I'll first start with how Mr. Makate looked at it and what would have been fair. He used what I think they call something about the look-back model.
Yes.
Now, the look-back model is not, you don't think of an idea as something that you're not sure it will be successful in the beginning.
Yes.
You only determine whether it was successful and therefore what compensation would be fair to you by looking back over a period of years of its success. So he was very adamant, Mr. Makate, that the look-back model informs his conception of how the calculations should be made. And he says using that model, he's calculated an estimated revenue generated by Vodacom on the idea alone. And of that revenue, he then says, I'm entitled to a particular percentage based on the initial agreement that Mr. Geisler and myself had, right? That's like I said, Mr. Gees, I don't know if he's still with Vodacom, but it's not for me to say anything about him anyway. But that's how he looked at what would have been fair, and that's why he's been pushing in the range of $1 billion plus as fair compensation because of the estimated revenue generated. And he relied on two financial reports of both Vodacom and Vodafone.
Yes.
So which were estimating the revenue generation in numbers above $1 billion, right? And hence he said, I'm entitled to a particular percentage, and this percentage is towards this amount. That's what he considered to be fair. In my view, what would be a fair compensation, taking into account the risk, as you said, of marketing the idea, the risk of even taking the idea in the first place without knowing its potential success. And look, it wasn't without hurdles to get the idea to succeed, because at some point there was a contestation of whether the idea originates from Vodacom or whether it comes from MTN, right?
Yes.
There was that sort of and accepting that form of idea as a company, you are assuming the risk of taking on litigation and prospective challenges and so on. So we, in our analysis, must be fair, at least to both Vodacom and to Mr. Makate, and say both parties took a risk in the idea, right? And for that, it's more like a joint business venture to see where it would land. And if it does land, then I don't know, depending really on the circumstances in the case, parties would be able to, should be able to come around the corner and say, in our view, based on what we've put into the idea and making sure it's a success, we think we're entitled to 60% and we think you're entitled to 40%. But it really depends on the merits of the case. And it's for the parties to make that decision.
Yes.
And this question, I must say, is not an easy question to answer, Mr. T. And that is why this matter took so long. Because in all the judgments, there is not one judgment where a court made a determination of how much Makate must get. In all of them.
Very complex calculation.
I mean, last year, they were told they must go back and negotiate.
Yeah.
That's what they were told. This year...
Because you would expect the court to just make a determination itself.
Let's talk about that, right? Let's talk about that because when on just a normal case, when you take a matter on appeal to the Constitutional Court, legally, that means you think the outcome that has been given by a lower court is wrong in law. It's erroneous. And you are saying the court must correct that judgment. That's what an appeal means. Now, in this case, Vodacom went to the Constitutional Court and dared the Constitutional Court, one, to say the SCA is wrong in law. They've made an error. Secondly, that you must correct the error. What did the Constitutional Court do? They said, we agree.
We agree they are wrong,
but we're not going to correct it. It must go back.
We'll leave it up to them. They must reconvene.
And I think that,
because it was a lot. It's a lot to consider.
It's not easy. Hence, I'm saying this question is not easy to say what would be a fair, determination. It's not an easy question. But look, in defense of the courts, in fact, in the judgment on paragraph 43, Madlanga says the court processes are not about perfections, right? The court processes are not about perfections, meaning that courts themselves can be wrong. And he says, please don't hold the court to some abstract standard of perfection.
Yes.
Right. Madlanga is aware of this conversation we are having. The courts are aware of the complexities involved in this. He further goes on in making this point. He says, in Bennett, the court said that judicial officers are not superhuman beings who do not make mistakes. Right. Now, and I think it's important to trump that point to say that judges are not machines.
They're not.
You don't insert an issue and expect an automated response that is without flaws. And it does get difficult at times. Like in this case, I can't imagine if you were sitting and I was sitting in that bench, that we would have generated a perfect answer to this. And again, I want to emphasize this, that we're not dealing with this analysis on the basis of criticizing blindfoldedly.
Yeah.
We are essentially explaining what happened and also exposing some of the inefficacies of the system itself, the judicial system, because there is somehow an expectation that as an arm of governance, judiciary must produce perfect results. And it's not always the case. And another thing, unfortunately, judges are not always right.
Yes.
That is why there's a process of appeal.
That's why we have this process in place.
100%, yes. So yeah, so that's what I wanted to say about that in answer to your question about whether or not what would have been fair. Now, I want to then take this discussion to this point to say, now that the court said the SCA must fix its own mistakes, your question initially was, what was wrong about the SCA's judgment? And what did the Constitutional Court say about that? I think maybe you want to say something on that. Yeah.
No, I think it was just the 2 points that we said. Maybe I can just reiterate it.
Yes.
The court just basically stipulated that the court failed to consider key evidence, particularly the CEO's evidence on the calculations and why he feels Makate's calculation was wrong. The court failed to also make a clear indication without it being vague in terms of the percentage, the 5% to 7.5% range. The SCA ordered that Makate is entitled to 5% or 7.5%. And the court felt that the judgment needs to be certain.
Right, which I agree with.
There was too much vagueness regarding that. Other than that, it was a failure to consider key evidence, basically.
Well, there are a lot of lessons to pick from this. But as a law student or as a lawyer with ambitions to sit on the bench, I think there's a special lesson that one must take from this. It's that being a judge is not for the faint-hearted.
Not at all.
They say judgments are not personal, right? Because they are fixated on the facts. But my brother, between you and I, assume you were a sitting judge in the SCA. You penned the majority judgment. And Judge Madlanga, in his judgment, considering an appeal from your judgment, says the following, and I want to quote what he says about the majority judgment in the SCA. He says, "Unfortunately, I cannot but say that the judgment is thinly reasoned. At times, it is characterized by a confusing reasoning. At other times, it is characterized by statements that evidence is a disregard for, At other times, it is characterized by statements that evidence a disregard for a lack of awareness of the facts and issues. Some examples of the confusing reasoning are as follows. The judgment says that Vodacom was not happy with the fact that in its 2016 judgment, this court finally dealt with the matter on 5% of revenue generated basis. This court never determined a percentage. Mr. Makate pushed for a 15% revenue share. The court declined to award that. Instead, it held that reasonable compensation had to be arrived at through a negotiation between Vodacom and Mr. Makate, failing which it had to be determined by the CEO. You were a sitting judge, my brother, in the Supreme Court of Appeal.
Yeah.
You are told, remember, it's not like you woke up and wrote that judgment. You worked, right?
There was also a part where the former justice indicated that this judgment looks like a copy and paste of the of the amended notice of motion. I found that quite funny. so look,
you know, a lot of people don't understand the strain that comes with being a sitting judge because these are some of the things and
there's time pressure as well.
Correct.
Yes,
because of the inundation of matters, because our courts are extremely inundated. And I think it's something for the Chief Justice and our government to consider, that there has to be an increase of court buildings,
Yes.
and subsequently an increase of court judges or judge appointments. Because in Gauteng alone, if you look at an urgent court roll on Tuesday, and on which only 2 judges sit, it's almost humanly impossible that one judge can deal with the amount of matters they have on their roll. And that also speaks to the constitutional rights to access to justice, because access to justice does not mean having access to courts only. It also means having access to quality consideration of matters, But yeah, that's what I wanted to say.
Yes.
Yeah.
No, I get you. And digitizing everything.
Yes.
The higher courts are doing it. I think at a MAG level, I don't know how far they are with developing that.
It's a mess. And maybe someday we should set time apart to talk about Magistrates Court. It's embarrassing. I must say this because I'm a practitioner. It's extremely embarrassing. It's extremely embarrassing for the Department of Justice to be okay with how things are at the Magistrates Court. And this is a general statement because it's applicable across the country. Magistrates courts do not have a proper adherence to its own regulations. Magistrates will set matters down for 8:30 every day without explaining why they arrive at 10, at 9:30, at 9 o'clock on awkward intervals. No explanation is given to the people who litigate in those courts. And guess who litigate in those courts? It's mostly African people.
Yeah.
There is a huge disregard
Yes.
for the work that must be done and for the people who actually rely on the magistrates court for justice.
And there's no real uniformity. Yes, they have the rules, but you'll find that there's one practice in Pretoria that's different to Johannesburg. I had a matter where I was instructing a correspondent.
Yeah.
She told me that, no, I had to travel to court to request the file. And then when I come back again, I'll see what's in the file. And then I'll go back to you. You tell me what to do on the file. I go back. I request the file. I come back on another day. So you see.
That's 2 weeks, 4 weeks.
That's about 4 attendances from one correspondent.
And guess who has to pay for that?
The client.
And they are litigating on a matter of low quantum. That's why it's in the magistrates court in the first place.
So now does it become economically sound for them to litigate if claiming
that's the case?
Right.
And isn't that in itself a constitutional impediment to right to access to justice? Because what it does is it prevents people from obtaining the justice they should in the magistrates court.
100%.
And nobody's talking about this. And I guess that's why the Cooper Show is here.
Yes.
Because this is utterly unacceptable.
It is. It's
utterly unacceptable. Each magistrates court has, what do you call the leaders in the magistrates court? It's
senior, what's it?
Chief magistrate.
Chief magistrate.
Chief magistrate.
Yeah.
And all these people, as you said, have their own rules and codes that are different from each other. The Benoni one has a different one. The one in Alex has a different one. The one in Pretoria, Joburg Central. Why is there no uniformity when the rules and the laws that should be applied in these courts are the same?
And when you do ask, where in the rules does it say this? You'll be told, no, the chief magistrate said it must be like this. or the senior magistrate said it must be like this.
And unfortunately, there's nothing I can do. That's just a lazy answer. And I think I don't mind people being lazy if they want to be, but I do mind when it affects the people. Because
the most
that's what it
destitute
does.
People go to the lower courts,
And I think we must say this, Mr. T. You see, my experience since I've practiced, which is a considerable number of years, you would know, the magistrate courts, and this may not be a practice applicable to every magistrate, but in the main and in the majority, in my experience, the magistrates only receive files in the mornings when they have to deal with the matter.
Yes.
If you receive a file at 8 o'clock for a matter that you have to adjudicate on at 8:30, it means you don't know anything about that file. You rely on counsel. But it's hard to rely on counsel when you haven't read the papers, because then you're not sure whether counsel is right or wrong. And even your questions may be very irrelevant, and you are wasting time, because if you read the file, you could probably dish a matter out in 15 minutes and move on to the next one.
Which is exactly what former Justice Matlanga was saying in this judgment, is that the courts need to consider these matters properly.
But then with high courts, I understand, because you see, once you get that type of lashing from the constitutional court, chances are you're going to act better.
Yes.
Magistrates don't really have that. Even if the high court says on an appeal that the magistrate was wrong,
yes,
there are no consequences. You're not going to, well, at least I'd like to think, you're not going to find the chief magistrate going back and saying, but why I want accountability. Why was this matter not properly considered? And that is why when you see magistrates striking and saying, we want an increase, that must be balanced with, we want to be better.
Yes.
We want to do our work better. I think those are some of the things that should be considered.
Yes.
I'm expecting a backlash for saying these views, but this is the Cooper Show. We say things without fear, favor, or prejudice.
Yeah. I want to also touch on that. Magistrate salaries.
Yes.
We want them to be in an economically good position so that they can do what? Consider matters properly. And what kind of effect does that have, on you as a professional when you're earning well versus when you feel like you're not earning what you should be? Because I think we can criticize magistrates, but at the same time, there may be impediments to them doing their work.
Correct. Look, I think fundamentally the problem with the manner in which magistrates courts are set up is that they don't fall under the judiciary. Fundamentally, that's where the problem is. So their salaries are not determined by the judiciary. They're determined by the Minister of Justice or the Department of Justice and the Office of the President. And I think as just on structural governance, that's just wrong, because there are matters which may end up in the magistrates court against departments of government. So that's government versus government.
Yeah.
And there's something fundamentally wrong about that.
You're not really going to poke the hand that feeds you.
Yeah, look, there's a lot of unlawful arrest matters where they sue the Minister of Justice and they sue the Minister of Police. And some of them end in the magistrates court. Fundamentally, just on governance basis, there is something controversial about that. There's something wrong about that form of setup where a Department of Justice is being litigated against in a court of its own, because that court belongs to it in terms of regulation. Secondly, then there's an issue because the minister may not be interested in how much you are earning and how much you are not. And the minister there's no requirement that a Minister of Justice must be a lawyer who has practiced. So from what we know, they could be, you could literally be in that court and the minister may not even be understanding the issues magistrates are facing. Had this been, a fell under the judiciary, the Chief Justice would understand the issues that magistrates are facing. And it would be easy for her to understand the need for the work they perform to be proportional with the compensation they receive. But because of that, that's where the issue, is. And that's why they even go on strike, because they say we've considered litigation, but no one is listening.
Yeah.
So I think for me, I agree with you. They must be incentivized so that they can work. And also they are under-resourced. As much as we criticize them, I mean, you go to those courts, you were talking about them having court online and all of that. They don't. And chances are they won't. If they do, it would be 10, 20 years later, because it's just so slow.
Yes. And also if they're underpaid, they're also susceptible to influence monetary influence, corruption, bribery.
Yes.
So you want your public officials that are in those key positions not to be in positions where they might be susceptible to things like that.
I love how you put it. And I just want to make it clear for the record. Mr. T says they are put in a position where they are susceptible to being corrupted. He did not say they are corrupt.
No.
So we don't want issues. I just had to put that on record. They are, and I agree with the statement, because what it does is that it says, although court officers ethically should not be susceptible to being corrupted,
yes,
you should not create an environment conducive for corruption to thrive.
Yes.
And that message, I hope it lands on the office of the Minister of Justice.
Yes.
Because it's important.
We stand by it.
We stand by it. No, without fear, favor. This is the Cooper Show, Mr. T.
This is the Cooper Show.
Yeah. So I don't know. Just to wrap up, because I see we're running out of time. Where are we now on the Makate case? So we know what the judgment says.
Yes.
There is a development that's been reported. Where are we?
In terms of the case? So there has been a settlement out of court.
Right.
Since the judgment from the Constitutional Court.
Yeah.
It's unclear how much the amount is that was eventually settled on between Makate and Vodacom. I do suspect it may be in the region of around 700 million.
Right.
I am not sure as well. We'll need to, if any of our viewers can confirm it, please do drop a comment. Yeah.
Yes, I understand at the moment Vodacom refused to announce the amount on the basis of its confidentiality.
Yeah.
But it did say that people can look at its financial reports to determine what, and like you said, the estimation is around 700 million to 900 million.
Yeah. So they on their own financial statements, at some point, they made provision for 970 million as a contingent liability. So if I'm not mistaken, contingent liability for this claim, in case, they lose the claim, then they've got that amount.
Yes.
So I think even in their financial statements, they sort of gave an idea of how much they'd be willing to settle.
So reasonably from that, we can then assume that it's nothing beyond 970 million.
Yes.
Which makes sense, right? Now, it sounds like, it's shy of 1 billion, right? Just a not shy of 1 billion, right? And it sounds like it's a lot of money, but there are claims against this this thing, and simply because Mr. Makate funded, you said he was a trainee accountant, so clearly he would not have had enough funds to fund litigation for over a period of 10 and above years, So this was funded, his litigation was funded by investors.
Yes.
This is what is called sham party agreements. I believe. I think a lot of candidate attorneys must pay attention to this, because I think they write on their board exams, they ask them, things like the difference between contingency fee agreement and sham party agreement. So this was more a sham party agreement of litigation funding type of matter, as opposed to contingency fee funding type of matter. So understand that there has been, people who funded this, and obviously they are entitled to a particular percentage. And maybe just to explain, a sham party agreement simply means that a particular investor funds litigation, and in return, they obtain a particular percentage, which is agreed upon in the beginning for funding, on the basis of whatever amount that has been recovered. Right. So I understand there are developments, notwithstanding the fact that there are various people who funded this litigation.
Yes.
But now, with the settlement, as Mandela would have said, once you climb one mountain, you realize there's many more to climb.
There's many more to...
Can Makate catch a breath?
Yeah, you really can't. So now, on his version, based on media reports, I haven't heard this directly from him. On his version, there's a company called BlackRock, BlackRock Mining, I believe. Right. It's claiming that it signed a contract with Makate through a legal representative. And in terms of that contract, they would be entitled to 40% of the proceeds of this litigation. right?
40.
40%.
It's a lot of money.
That's like almost half. And so far in the litigation, the BlackRock's attorney that I saw on the news was alleging that they've spent over 5 million in the litigation, and they would pay all the amounts for the litigation to the lawyers directly, and they've got receipts, and that they're currently pursuing an urgent application and interdict. So I think we need to just follow that closely and see what the outcome was.
It's a developing story.
It is a developing story.
It's one to keep an eye on. I mean, I think also it's really important to, I think for Mr. Makate, this is another lesson that even when you're desperate, because I think when you start litigation about something so big, you probably would get an element of desperation in terms of getting it through. So you would take even the most ridiculous percentages offered, because 40% for me is ridiculous.
And I suppose that's why you couldn't give up at some point, because it was like, if I'm going to accept 50, 40 is going to BlackRock. The other one is going to Peacock Investments. All right, viewers, there's no Peacock Investments.
Yeah.
You get what I'm saying?
I get what you mean, because there's a number of hands who are claiming entitlement in this. And that means he's only going to get, whatever is left after deductions.
Yes.
And that's, again, that's another stress, I think, for him, because would you say then, though, that the courts have failed him, given the amount of time this litigation has taken, obviously the costs that are involved? Would you say the court system has failed Mr. Makate?
Well, in the context of South Africa, a case this high profile and complex, I think, 10 years, yes, but 20 years was a bit of a stretch.
Yeah.
20 years is just too much. I do understand litigation takes years.
Yes.
But I think 2 decades is just too much.
It could have been more, because, you see, if they did not settle, you saw what happened in July. The Constitutional Court said, whilst we think you are wrong, SCA, we want you to make it right. This thing must go back. And I mean, I found the reason, I don't know, I don't think I agree with the reasoning, right? The reasoning of the judgment says the Constitutional Court sits as a court of last instance. Its function is not to determine and establish the facts in matters. So it's not a court that must be litigated, or litigation in that court should not be on the facts. It should be on the law, whether the law has been correctly applied or not, right? And they say, because the SCA failed to consider the matter properly, there are facts which still have to be established in that court. And that's not for us to determine. Now, you see, this reasoning sounds correct, but I'm of the view that because when it suits the Constitutional Court, they shift the jurisprudence of that court to a particular angle that they find suitable at that time. Because I know matters which should not have been in the Constitutional Court and were decided there. And an example, without fear, favor, or prejudice, of one of the matters that ended up in the Constitutional Court and were instantly decided there, where the facts were established in the Constitutional Court, and caused a lot of problems and a lot of controversy for our jurisprudence, was the famous Secretary of the State Capture Commission versus Zuma, the former president. That matter went on direct access to the Constitutional Court. The Constitutional Court entertained the matter. In my view, that's a matter that should have went to the High Court. Then Constitutional Court would have benefited through jurisprudence and decisions which are made in order for it to make the final decision. But no, they accepted to hear that matter. And it landed them in a lot of problems, because for the first time in the course of our democratic constitutional dispensation, we have a judgment of the Constitutional Court, a minority judgment, which says the majority judgment of the Constitutional Court is unconstitutional. For the first time. Do you know, Mr. T, in law, when you say something is unconstitutional, you mean that it violates fundamental rights of someone. You can't surely expect a court to make a judgment especially a court which is a court of last instance. You can't go anywhere after the concord. To make a judgment that other judges sitting in that court think it violates the fundamental rights of a citizen.
Yes.
So, by all means necessary, when it's suitable, the concord has jurisdiction, and when it's not suitable, the concord has no jurisdiction. And I think there are various articles that shows the inconsistencies on how the concord has ruled on its own ability to hear matters, on its own jurisdiction. And I think it's something that, should be given a thought, especially by the sitting judges.
Okay. No, definitely. I hear your argument, sir. Yeah,
look, we say these things without fear, favor, or prejudice because we know that, look, I on the last episode we showed, I was contacted by a sitting judge who told me that they actually appreciate our views.
Yes.
Why? Because this platform
honesty
is honest and diligent and speaks with integrity.
Yes.
Right.
Yes.
Without fear, favor, or we favor no one. We just favor the law.
Yes. 100%. 100%.
Yeah.
I also felt, maybe the Concord could have just made a determination of the entire matter, because now they've sent it back to the SCA. If that process doesn't go well, it would have probably ended up back at the Constitutional Court again.
Chances are it was going to not go well because they would not have found each other.
Yes.
And it would have went back to the Constitutional Court. And the Constitutional Court would have probably ruled on it finally, or would have said, no, you must go negotiate again.
Yes.
Which I think, personally, I think that the entire handling by the judicial system, not a specific court, just the judicial system of this matter, was unfair on Mr. Makate in a sense that the system failed him because the Constitution itself, and on many occasions, the Constitutional Court itself, including in the Zuma and the Secretary of the State Capture Commission, the Constitutional Court itself said there must be an end to litigation.
Yes.
As a fundamental principle, there must be an end to litigation. Litigation cannot go on and on and on.
Yeah.
Now, if you fail to bring an end to litigation, you as a system are failing the litigants on a right to access to justice. So when you now make, I'm thinking of the look-back model that Makate employed. I want to employ it in the judiciary. Well, now you take a look-back model and you look at the courts themselves in how they handled this matter. I'm not too sure if I'd come to a conclusion that they emphasize the principle of litigation having to come to an end as they should have.
You would have thought that at the Concord, there would have been some form of finality to the matter, and that's it.
Yes.
But
Well, I think at some point, judges are afraid of getting their hands dirty. And sometimes I think as a judge, and that's why I agree with Advocate Moses Kakane SC, when he says being a judge takes a special person. If you don't have a special personality, don't go to the bench. It's for the called few, where you don't mind being criticized, where you don't mind getting your hands dirty for what you believe is true.
Yes.
Should we call it an end?
We should.
It's been an episode and a half.
Yeah.
It's been an episode and a half. Well, folks, you've heard it from us. Today, we wanted to dive deep into the Makate case. As you've heard, here we dish it out to you as fresh as it is. Finally, Mr. Makate and Vodacom have found each other, and they've reached a settlement which is estimated to be in the range of 700 million or above. And unfortunately, Mr. Makate would have thought this is an end to his woes. But BlackRock is now claiming a particular percentage from whatever amount he would receive. This is a story we are going to keep our eyes on. And as and when there are developments, you'll definitely hear fresh, better quality analysis. This is The Cooper Show.